getting more political elitist, urban-centric, and rich people-centric, than taking it to the grassroots, to the marginalized people, for whom this rights really matter. And unless we take into account the life experience of those people and do not bring out any changes with the help of the Human Rights Action Plan, then our discourse will be limited again to the academic level. My worry at this point is that where the Charter itself, the SAARC body itself, is getting limited to formal diplomatic level, it is going beyond to the people across the region. That's the point. And for the first time, I think the South Asian University can be the reflection of the aspiration of the SAARC Charter. This can be taken one instance. And I think this institution should be taken as a seed, and through which whole South Asian region should be allowed to grow. It may take time, but the seed must be allowed to grow, and we must put our energy and resources to get it grow. So this is my concern, because our South Asian population is heavily, this is the region where the world's largest poor population live, below $1 a day. So this is a worrying factor. And for me, when we talk about the poor people's experiences, then poverty means comprehensive violation of rights. Not to talk about our single right. If a person doesn't have a right to a better right to life, or if a person doesn't have a right to education or employment, then other rights also will be affected by that. If a person doesn't have employment, that means he or she doesn't get the income, and without the income, then he or she cannot maintain the family, or cannot give education, or health, or other rights, or other set of rights will be affected by way of affecting one. So the interrelationship of rights will have to be understood. I fully agree with Professor Gunasekaran when she said that the economic, social, cultural rights should be is justiciable. We had the occasion to decide some of the cases in my jurisdiction in Nepal, where very clearly said the rights are interrelated, it cannot be separated. I don't believe in the generation of rights. There is no generation of first generation, second generation, third generation. This is my personal view. Rights are rights, whether they are civil, political, or whether they are economic, social, cultural rights, or environmental or information, whatsoever the rights they are. But they are rights, and they have to be recognized at once, protected at once, and the benefit of those rights should be reaching out to the people who need it most. Unless that happens, then, again I say, then rights will be elitist, urban-centric. Very few people will be getting the benefit of those set of rights. So, whether we are talking about the universal declaration, the rights are not universally declared. They are meant for universal protection and enjoyment. The universal declaration of rights doesn't mean that they have been universally declared. Declaration is not enough. Rights are not meant for the declaration. They are meant for the enjoyment. And the enjoyment requires the ability to enjoy the rights. And when we talk about the poor people who in majority live in this part of the world, they don't have the ability to enjoy the rights. If they don't have the ability to enjoy the rights, what's the use of writing those rights in the Constitution? We may give a very glorious space to them in our Constitution, but they would not reach out to the people by themselves. That's a serious concern. Then what matters is that we have been thinking that economic, social, cultural rights are the declaratory rights. They need to be progressively implemented by the use of the scarce resources that may be available at the hand of the state. But the state has to be obliged to explain why they cannot spend the scarce resources for the realization of the economic, social, cultural rights. The right to budget is very important. We don't recognize budget as a right. But right to budget is also a very important right to be considered. Because the budget is not simply a matter to be spent at the hand of the finance ministry or the executive of the day. Budget should be equitably, reasonably spent on the realization of rights. These things we do not consider. My personal belief is that perhaps we did not have a dialogic relation between economics, polity, and the law. Economics and the law falling apart. They are sitting in different directions. They don't have a dialogue between themselves. And polity also is sitting apart. So this trinity of the elements, economics, polity, and the law, they need to speak together. That means it requires a political economy approach to the implement of the whole set of the economic, social, cultural rights, which is not happening so far. I do not know where you are now, but I may personally call upon the South Asian University to undertake some research how the political economy approach towards the implementation of the economic, social, cultural rights can be put in place. We need to bring the people together from different disciplines, from different organs of the state. They need to sit together, they need to talk to each other, and everyone has to be accountable. Professor Gunasakar is right. It is not that only the states are responsible, even the non-state entities also are responsible. And within the state also, it is not that only the executive or the legislature have to be responsible, but the judiciary has to be responsible. You know, what many important ways the judiciary would have contributed that can be inquired into. I believe in the recent time, mainly I would like to pay tribute to the contribution of the Indian judiciary, particularly when she said about the Bhagwati court, that actually liberated the narrowness of the standard. And now we have a very broad-based PIL jurisdiction in our country. The Constitution formally recognized the PIL jurisdiction, and this jurisdiction has given us immense opportunity to decide upon many of the important issues of public importance. And the issues relating to the poverty and the people have been directly and indirectly have been touched upon by way of the judicial interventions. I would not say that judicial intervention have been robust in all senses. There could be problems with themselves. And more importantly, the implementation of the judicial orders also could be a very serious problem. And if the judicial orders would not be implemented, that could be a serious rule of law issue. My impression is that across the South Asia, though we are in varying degree of development, I would not generalize it, but I have the impression that we have a serious rule of law deficiency syndrome that will affect our development, our justice needs, and at the end, our democracy deficiency also will be created out of that. So these are very serious issues. So I'm not trying to be very legalistic now at this point of time. The contribution of the judiciary or the legal community can be appreciated. They have done their part in history or in appropriate occasions. But more importantly, what is important for now is that whether the people in general, the marginalized people, have the experience that they are benefited out of the human rights discourse that we are talking about. Unless we can draw upon some evidence that they feel that they are exasperated, they are getting some benefits, they have some satisfactory experiences, we cannot satisfy ourselves. A judge can be happy with the protocol, a security, what is accorded to. A lawyer can be happy with the accumulation of the resources one may be able to do amid so much of the scarcity in the society. And even the legal community, academic, they may be very happy with the knowledge they hold and the point of distinction they hold in society. These are that. But are we entitled to that? My point here is that we as people need not be segregated. We need not be distinguished. Because we belong to the same human form. Why A and B should be differently treated? The question is that in what effective manner we render our services, where our services are reaching out to the people whom our services need most. That should be, our services should be respect-worthy, not we as people. Everyone has a same sense of equal worth. One is not less important than the other. Everyone is equally important. The importance doesn't lie in our personality, but in terms of the capacity to contribute or in the contribution. So these are the very serious issues, and it should be a brainstorming session to dramatically revisit what we might have thought about and what new course we may be able to regarding South Asian context then we have never been able to bring out the South Asian perspective, neither the South Asian Charter. I think I have never seen that it gives some scope for us. But my personal opinion is that under the aegis of the SARC, there has been some conventions. And if some conventions in some sectoral area are possible, why it is not possible to bring out a human rights charter for the SARC region? It should be possible. We should be able to bring out the Human Rights Commission, if not the court at the moment, to inquire into the human rights situation in the area, to bring out the academic together, to make the research together, to make certain recommendations, so that our experiences are harmonized, equally experienced, and whether they are allowed to reflect in their national legal system or policy processes. So these are the expectations. So I think the discourse that we have been taking on this time is very important discourse, and it should not be end up right now with the conclusion of this seminar. It should be rather a starting point to take on further till that we have a fully blown human rights institution for the region as a whole. That should be the dream I think we need to dream together. With these words I would like to conclude here, and I would be happy to share my experience further. Thank
you, Mr. Shrestha. I have the pleasure of having Dr. Hussain here, and I would request if she could, Madam, please make some remarks. Kindly, please.
Thank you very much. I'm afraid I feel a bit of an interloper here with so many eminent lawyers and other academics. I'm not a lawyer, and I'm not invited to speak otherwise. But anyway, we've heard a lot about the law and how the courts are interpreting the law to make it possible for us to realize our human rights and our rights within each country. But I think I'd like to give, there's also a different side of the picture, because I think very often what we get from lawyers and judges and so on, and some of them can be very conservative in fact, is beyond our comprehension, the comprehension of very ordinary citizens who don't seem to know what their rights are in any society, and leave alone their own rights. I mean, the international human rights are very far from their lives, particularly if you ask a woman who's being battered in a domestic situation by her husband, and she doesn't know that she has rights. So I think there is another side of the picture which I would like to very briefly talk about. When I first met Kamal, he was very keen on my becoming a lawyer, and I resisted it because I found all these men in black coats and black trousers marching down and acting very superior to everybody else. And I said to the ordinary person, I've studied history and I didn't know anything about the law, so I avoided it. Then about 25 years ago, I don't know why, but I got together with 8 other friends, and we started a human rights resource center. It was known as Ain Oshalish Kendra, which is Law and Mediation Center. And our objectives were to reach out to the ordinary people. So particularly want to reach out to women, to workers, and particularly child workers, and see how we could try and help them either settle their disputes, whether it was marital disputes or disputes within the community, or in other ways to help them through the courts. We also had some lawyers on our committee, so we could do that. And our first experience of telling women, well, why don't we support you legally? And they looked at us and said, oh, but lawyers take very high fees, and we don't understand what they tell us. We don't know what our rights are. So then we changed our tack, and we started going to them and telling them what their rights are. And then the women would come back to us and said, oh really, I can divorce my husband. I was told by somebody in the community that I couldn't do that, only he had the right to divorce me. So that is how I think law became more meaningful for people, when you go to them and tell them what it's all about, and then they can struggle for their own rights. So the other side of the picture I want to give just 2 brief examples. How it is very important to have citizens who are willing to be active, and it is through citizens' activism actually that I think our court system work more effectively, and they're able to give more progressive judgments which support people's rights. And the first instance I would talk about, it's more than an instance, it's an episode, is Kamal Hussain talked about the right to shelter. But the way it began, the way we took up the cases for right to shelter was, I remember in 1989, when a friend of ours telephoned us at the Human Rights Center, and they said, you know, the bulldozers trying to bulldoze these shacks, and the child who's been killed in this process. So we immediately got a whole band of young lawyers together, and they took up the case in court, and that was in 1989. And evictions haven't stopped since then. The last eviction is still on the cards, but progressively, each time they've tried to, the government executive powers have acted to evict these people and then convert the land to whatever profiteering motive they might have. We have stepped in, lawyers have stepped in with support from citizens, and while lawyers are arguing in court, the citizens are trying to provide other kinds of support. And we have then, over the years between 1989 and now 2017, we've got very progressive directions from the court that you cannot evict people from the shacks that they built for themselves without proper alternative plans to resettle them somewhere else. And I think this has helped not only the jurisprudence, but it's also helped ordinary women, ordinary men who are living in these shelters, who are in fact sustaining our middle class lives in cities like Dhaka and Delhi, to stay where they are. And in fact, then this is a way of recognizing the international human rights to shelter, which we've got in Istanbul and various other, through other social economic rights conventions. The other example I would just briefly talk about refers to women's rights. You know that there is something in Islam called fatwa, which is really an opinion that people who are aware or very knowledgeable about Islam, only they give these fatwas. But in Bangladesh, and I think countries like Pakistan, there has been a sort of customary traditional practice of imams or leaders, religious leaders, issuing fatwas, which prescribe very harsh penalties, both physical and such as whipping and lashing and so on and so forth, or social boycott, which is much worse for women. And the first instance that came to our notice in the Human Rights Center was a fatwa issued to a woman in 1993 in a very remote village. And the fatwa was issued by an imam, and he was supported by 8 other men who came with him in a very isolated place, and gave a fatwa saying the woman has to be penalized because she has sinned, because she was divorced and she's remarried. Not only was she penalized, but her second husband was penalized, and her parents were penalized. And at the tail end of it, one of these leaders came up to her and said, if I was you, I would be so ashamed I would kill myself. And she did, but precisely that. She went home, ate rat poison, and she was dead. So this news came to the women's groups in different parts of the country, and we immediately sort of rose to the challenge. And while a lot of women then gathered around organizing protests and so on, that we don't want, this is not the law in Bangladesh, we cannot allow such illegal activities. On the other hand, the matter was taken up by lawyers in the courts. And after 7 years, the imam was convicted or sentenced. I think it was 7 years. But subsequently, after this incident, we began to hear about other similar incidents in different parts of Bangladesh, in villages mainly, all dealing to do with a domestic situation. A Hindu woman had married a Muslim man, or a Muslim woman had married a Hindu man, therefore she was given a fatwa and she had to be lashed, and several other reasons like that. And each time then, the women's movements became very active, women lawyers and others, and they started processing this in court. But at the same time, we also engaged in public campaign to build opinion, public opinion against this, and also to see that the woman who is being, on whom this punishment is being inflicted, that she should get some protection so that she doesn't end up committing suicide herself. And I think again, once between 1993 and now, we have again had very progressive judgments. The last judgment from the Supreme Court in 2014, said very clearly that fatwas which prescribe penalties are illegal. And this was issued even even after facing various sort of conflictual situation which was started by the religious leaders who had rallies on the street rallies and so on and so forth. But our judges, luckily for us, I think, luckily for the women's community and luckily for justice in Bangladesh, that they stepped out and said they made this whole process illegal. So I think just made these 2 points to say that, while we might get good judgments and good laws and so on, I think it's very important for citizens to be active and in order to promote and protect their lives. Thank you.
Thank you, madam.
Now, we would invite questions because if I could see the topic has been very comprehensively taken up by our distinguished colleagues, panelists. You can see that a very thematic overview we have received from Professor Gunasekre in doctrinal form. The rights, the sub-theme on core human rights interests of South Asia was very well taken up by Mr. Shrestha in the form of poverty, which is one of the Sustainable Development Goals 1. Women's rights, individual rights taken up by Professor Gunasekre, Professor Mr. Shrestha, Madam Hamida. Now, institutional aspect was also taken up, sub-theme participation of civil society, and finally of a very effective mechanism for South Asia. So I understand all these 5 sub-themes of our common theme they have taken up. And I'm sure that you must have some questions which would address your particular interest or concerns or whatever that you would like to reflect and hear from our panelists. So therefore I request you to identify yourself and put questions and identify your nationality so that they can have a comprehensive perspective to reflect. Thank you.
A very good afternoon to the esteemed panelists. My name is Shreya and I'm a first year LM student here at STAR and I'm from India. My question is to Professor Gunasekre ma'am. Ma'am, you talked about universality of human rights. So my question is, where would you locate the normativity of universality of human rights now in the South Asian region with respect to the objectives of SAARC Charter that relates to maintenance of peace and stability in this region through the strict adherence of the purposes of UN Charter?
This is a question to you. What I understand from her is she is talking about the
Yes,
SAARC
you want me to
Charter.
respond?
Yeah, SAARC, yes please.
Yeah. Well, I think the normative framework is very clearly established because you see SAARC is an organization which does not have a charter, so it's very much an issue of individual responses. So the normative frameworks are not as a collective. The normative frameworks are national, and I think that's a point that we have been making, that though for various political reasons, SAARC takes up mostly everything bilaterally. They don't want to get into multilateralism. I recall a time when I was on a drafting committee for SAARC at a SAARC conference years ago, in the 80s. There was a huge problem of cross-border trafficking across countries. Now we say there's a SAARC Charter on trafficking. Did you think that came easily? No. Because the governments would say, don't touch this topic. It's cross-border. SAARC doesn't deal with cross-border issues. That was the original thinking. So then, faced with the reality, and in fact there were objections to putting in trafficking into the conference declaration. I know because I was there. Now we have a SAARC Charter. So that is because the countries began to recognize that this is a regional problem of cross-border trafficking and they have to respond. However, having a charter, having a SAARC document on cross-border trafficking, how many countries have ratified? How many countries have internalized? My country actually did ratify, and my country has a law but it's never been brought into force. So we have individual initiatives, but not a SARC initiative. So we can't talk about the SARC normative framework. What we can talk of, the SARC normative framework is a general charter which says yes, all countries, good governance, etc. But the specificities of obligations are country specific, based on ratification of treaties, based on constitutions. And it is true that the constitutions bifurcate between directive principles which are not enforceable and enforceable fundamental rights. But that goes to our location in Western jurisprudence. When India drafted its constitution in 1948, there were still two covenants. It was pre-Vienna. So they also put that in. Non-justiciable directive principle, justiciable fundamental rights. But what happened was that the courts, Bhagavati Court initially, took the directive principles of state policy and said these are guidelines, but they must be connected to fundamental rights. And so they created the jurisprudence linking the two. Now we have gone further because the country's commitments undertaken by treaties have set the normative frameworks. CRC requires indivisibility. Disabilities Convention, which has been ratified by India, many countries, sets a normative framework. So does the CEDAW. So now the normative framework is in Constitution, in treaties, ratified, and SARC all the countries of SARC have ratified CEDAW and CRC. So it's like a universal norm. All the norms are universal. And then in addition to that, we have the whole concept of customary international law. Today no country can justify torture, which is why the criticism of the US and all that has happened in response to terrorism. Because genocide and torture are part of what you call jus cogens, customary international law. Every country is bound by that. So I think Hamida's point about the fact that yes, lawyering limited, it is true that lawyering is limited. And it is true that lawyering alone won't realize rights. It has to happen with other communication plus activism. And indeed the power of the human rights movement has been carried on the shoulder of activists. It is activists joining with lawyers that carried the jurisprudence to the courts. So the people are necessary, NGOs are necessary, it's not only the lawyers. But having said that, we have to recognize, in fact I think, Hamida, all your examples, you kept coming back to the fact that it is the lawyers who did the job. You know, you were the activists, but it's the lawyers who did the job. And that is a reality, because if you have governance and normative structures, they have to be enforced in some way. And I want to leave you with an incident that we had in my country where legal literacy is important, but legal literacy without the law creates aspirations without enforcement. So that's bad, because you teach them the law, women the law, they don't know what to do with it. In this instance, this woman came to us and said, I listened to your programs on legal literacy. You told me that under our law, I'm a war widow, and if I remarry, I lose my husband's pension. That's what you said. And you criticize the law. So what did I do? I went into a live-in relationship. I didn't marry. And I'm getting my husband's pension. Fine. Then what happened? Suddenly somebody came and put a petition, and the government said, you are married. You have got a child. So we can't give you your husband's pension. She said, I'm not married. I'm living with this man. I have a child. He's non-marital. The government said, no, you have a child, therefore you must be married. So what did she do? She came to the lawyers. She got pro bono advice, and they went to court, challenged, and said, this woman is not married. You have to give her pension. Either change the law and prevent remarriage being, because after all the pension is a pension, isn't it? It shouldn't depend on remarriage. This is the British original law with regard to widows and pensions. You have to have a